Right. Well, ladies and gentlemen, it's 1 minute past 3, and so good afternoon. My name is David Locke, King's Counsel. I'll chair the session today. I'm joined by my colleagues Leon Glenister and Charles Bishop, who I'll introduce in a minute. We do need to start promptly at 3 because we have to finish at 3:55 because some of us are committed to other things which start at 4 o'clock. I'm sure you know what it's like to have your diaries managed for you. And therefore, this is going to be a prompt session, but I'm sure that discipline will be great for everybody. Welcome to this NHS Legal Framework Masterclass, which is the second of the series that Landmark Chambers are doing. Today's webinar will focus on patient choice. And I'm delighted to see so many people joining the session today and hope you'll find the presentations and discussion to be useful and informative. To begin with a few housekeeping notes, your microphones are automatically muted, so you won't need to adjust your local settings. We very much welcome questions through the session. Please submit them via text in the Q&A section, which should be at the bottom or possibly the top of your screen. If you want to remain anonymous when you're asking a question, please make sure you tick the box "Send anonymously" before submitting your questions. We'll endeavour to answer as many questions as possible before the end of the session. The webinar is recorded. You'll receive a link to the presentation and the recording shortly after the event concludes. And if your connection is lost at any point during the webinar, we invite you to just rejoin us by clicking on the original link once more. So let's begin. I've been asked to say a few things about patient choice to begin with. First of all, can I make it clear that my present work as an expert advisor to the Secretary of State does not include policy on patient choice. So any observations I make in this seminar are strictly my own views, and I'm not saying anything on behalf of the government. But patient choice in the NHS has been a favoured policy of successive governments. Its laudable intention is to empower patients so they can make choices about who should provide them with the most personal service of all, healthcare services, and possibly to a lesser extent to decide what treatment they should have. It's all supposed to be about giving power to the patient. But I think a fair criticism is the regulations which give effect to this policy are of mind-blowing complexity. They leave many questions unanswered as they purport to give rights to patients. Speaking for myself, I find it a complete mystery how anybody who doesn't have an inside knowledge of how the system operates could possibly navigate their way through exercising patient choice in practice. On virtually every occasion on which, on behalf of a patient, I've been asked to advise on patient choice rights, I have to report that there's always been a reason why the right cannot be in fact delivered for the client who sought my advice. Now, that may say something about the complexity of cases that come up to silk, but it's also an indicator of the opaque nature of the regulations. So in a moment, I'm going to ask Charles Bishop to unravel some of the mystery and hopefully provide a guide through the maze created by the regulations. But before I do so, can I remind everyone about the Landmark Chambers and Legal Action Group's NHS Law Conference on Wednesday, the 5th of November this year, taking place in London. The conference will provide cutting-edge insights into a range of legal issues affecting lawyers, advising NHS bodies, those acting for patients, and those acting for NHS commercial partners. And it'll be a superb opportunity to network with other practicing lawyers in the field. And the keynote speaker for this conference, we're delighted to say, is Professor Emily Jackson, OBE, who will speak about the anticipated changes to NHS legal frameworks following the publication of the NHS plan and other developments in NHS law. Professor Jackson is from LSE, and she's a leading academic commentator on NHS law and was awarded an OBE in 2017 for services for higher education, and is always well worth listening to. So I hope the 5th of November will be a not-to-be-missed date for your diaries. So to today's webinar. Charles Bishop is going to give an outline of the framework on patient choice. He's a barrister at Landmark Chambers, a public law specialist, a member of the Attorney General's panel of counsel, and he updated the patient choice chapter for the NHS Law and Practice book, available in all good bookshops and probably a few dodgy ones as well. He's acted in leading cases for both patients and those providing NHS services. Charles.
Well, thank you, David, and good afternoon, everyone. As David said, I'm going to give an overview of patient choice, and it is really only going to be an overview because there is quite a lot that can be said. Indeed, the chapter in the book is quite lengthy on patient choice. So I'm just going to give a flavour of the various issues that come into it. But I just wanted to begin by asking the question, well, what is patient choice? David said at the beginning, it's a sort of laudable aim about giving patients greater autonomy or choice over their uh, healthcare. In a way, it sort of reflects that liberal or some might say neoliberal tendency that we saw in the provision of services, public services in the latter part of the 20th century and early 21st century, about putting individuals back in the driving seat over choices in providing services to them provided by the public. I put this graphic on here, though, to ask the question, well, is it a real choice? Do you actually get to choose between two meaningful alternatives? And it's a depiction of the famous concept of a Hobson's choice. So you can either take it or you can leave it. So is patient choice actually more of a political ambition or an NHS slogan? Or is it, in fact, a set of legal rights? Well, hopefully by the end of today's session, you might have an idea what you think. Just starting, though, with some of the things about where patient choice, as it actually works in practice, doesn't really help. So patient choice doesn't allow you to access any services that are not commissioned by your ICB or by NHS England generally, or services which are not available for some other reason. So I have in mind there, for example, the ban on prohibited medicines, such as the puberty blockers ban that happened last year. So patient choice can't come into that at all. It also has very little application in emergency situations, subject to one caveat, which I'm going to come on to at the end. Generally, when we're talking about secondary care, you're talking about something that depends on a referral from a GP. So there is a gateway there. However, there are proposals in the government's 10-year plan that might change that. And just finally, there are some problems that patient choice can cause for NHS England and ICBs who maintain contracts with NHS trusts and foundation trusts, which can result in them essentially paying twice because they have to pay both a block contract with the NHS trust and NHS foundation trusts, but then might also have to pay again if that particular trust is then chosen again for service under patient choice provisions. So starting then with the broad legal framework, it's always important to have in mind that there are two overarching legal obligations on both NHS England and the ICBs, which is to, in the exercise of their functions, act with a view to enabling patients to make choices with respect to aspects of health services provided to them. This is pretty vague language. It's also only an obligation to act with a view to enabling patients to make choices. This is most likely to be considered as something called a target duty, which means that NHS England and ICBs are given a very wide discretion to decide for themselves how to go about facilitating this duty. But what it does mean is that they can't act deliberately to restrict choices available to NHS patients in a way that would be inconsistent with this duty. However, really, that is the general. We need to look at the specific. So let's start with primary care services then. Well, the NHS Constitution says that every patient has a right to choose their GP practice and be accepted by it unless there are reasonable grounds for them to refuse it. And there also is a right to, once you're in a GP practice, you have a right to express a preference for using a particular doctor within the GP practice and for that practice to try to comply with it. But this is the NHS Constitution. It is not directly enforceable in any form of legal proceedings. It's essentially a form of procedural duty, which is under the Health Act 2009, which requires NHS bodies to have regard to it. So as long as they've had regard to it and have a good reason to depart from that, they wouldn't be in breach of the NHS Constitution or any legal obligation if they don't facilitate this patient choice right. However, on a grander legal scale, NHS England is prohibited from restricting the ability of a person to apply for inclusion in the list of a GP practice. for particular practice or particular performance or class of performer. And this is under the Responsibilities and Standing Rules Regulations, Regulation 42A. Well, what does that mean in practice? So in practice, the standard contract, which is operated by NHS England and governed by the National Service, sorry, the General Medical Services Regulations, includes provisions that help facilitate these contractual duties. However, one of the problems that arises here is that those are not actually enforceable by patients themselves, although they would be enforceable by the parties to the contract, because these are generally third-party rights which are excluded under the 1999 Act. Therefore, if you're in a situation where you're looking to find a way to enforce patient choice in the primary care field, you'd have to think about some quite creative solutions. So things like complaints, ombuds, perhaps an Equality Act claim, or even JR in a very creative sense. This is set out in much more detail in the chapter in the book. So what do these rights say, however, assuming that they can be enforced? Well, patients can apply to join the list of any GP practice that has an open list, so one that is not a closed list and not lawfully closed. A GP practice can then only refuse an application if there are reasonable grounds for doing so, and that don't relate to what are essentially protected characteristics. A reasonable ground might be residence, so that is a basis on which a GP practice can refuse to accept someone onto an open list. And there are obligations to comply with patient preferences as to practitioner. But the overarching message I have here is that everyone has a right to decide which GP practice they want to join. There are some restrictions around residence, but generally speaking, you can go where you want. And you can, once you're in there, also choose who you have as your GP in the primary care sector. So turning then to secondary care, and just want to set out really here the broad picture. First is, again, you've got some provision in the NHS Constitution. Secondly, the Department of Health also maintains something called the NHS Choices Framework, which sets out at the national stage the choices that are available and have been nationally determined, and really doesn't, I would say, add to the legal framework, but kind of provides guidance as to how it operates. That is also supplemented by the NHS England formal guidance. And then finally, you have the actual legally enforceable rights, which are contained in parts 8 and 9 of the Responsibility and Standing Rules Regulations, parts 8 and 9, which itself derives from statute under the 2006 Act, and which was bolstered by the Health and Social Care Act 2022. So at a glance, because we don't have lots of time, and because Leon is going to be going into this in a bit more detail and looking at how these rules operate in some common sets of circumstances, I'm just going to briefly go through how the patient choice rules work in secondary care. So the first is that you have two stages, really, when the choice might arise. First is initial referral by a referring clinician. So you've gone to your GP and the GP says, yeah, I'm going to refer you to see, say, an oncologist, or, well, actually cancer is slightly different, but you're going to be referred to see ear, nose, throat surgeon. And you have a choice at that point where you go. There's a second choice, which is where you have the waiting time for that particular service. The standard waiting time that is required for that service has been breached. You then, there's another choice that becomes available at that point. So starting with the initial referral stage, and in essence, patients have a legal right to choose, and I say in essence because I'm summarizing some, as David said in opening, some very complicated provisions which are set out in a few regulations, across a few regulations in that set of regulations. But patients have a legal right to choose the secondary care provider to whom they are referred by their NHS GP or dentist or optometrist, where the clinician decides that the patient requires an elective referral. Now, all of these terms have detailed interpretive provisions. There's not a huge amount of case law in this at all, which means also that there's an inherent degree of uncertainty as to how any court would interpret this, and therefore an inherent degree of uncertainty as to how you can advise NHS bodies as to all patients as to how the obligation should work. But just picking out a few details within these regulations. The first is that you need to require a referral, but that can be for any service to be provided, unless that's been specifically excluded in the regulations. It doesn't apply to referrals that are immediately required. So this is what I was saying at the beginning, that generally speaking, we don't consider patient choice in the realm of emergency treatments. It does also apply to what we call interface services, and Leon's going to touch on what that means in practice by reference to referral hubs in his slides. And it also only applies to referrals to service providers that have a commissioning contract with an ICB or NHS England. Now, that's quite important, and Leon is going to explain what that means in practice, because actually the effect of it is that the bride can be broader than people might expect. So that's the initial stage referral choice. There's also a choice that arises in another situation. So this is the general principle is that a patient referred for secondary care and treatment, which is not commenced within 18 weeks or will not be commenced within 18 weeks as required by the regulations. In that situation, Regulation 48 imposes a duty on the commissioning body, be that the ICB or NHS England, to take all reasonable steps to ensure that the person is offered an appointment with an alternative provider. Now, really, I'm not sure that this can be considered a choice, because actually it's more of a duty on the commissioning body to find an alternative, which may involve offering a choice of alternatives, but actually the duty is just to provide an alternative. Within this, however, there is a wider pool of providers which are available. There's not a requirement here to hold a contract with an ICB. Reality is this is rarely exercised in practice, notwithstanding the fact that, as we all know, this waiting time standard is regularly breached. So that's very broad overview of what I might call domestic patient choice. Just briefly touching on something else, which is, can you ask the NHS to fund treatment abroad? Can you choose that as a patient? Well, there is a discretionary scheme operated by NHS England, which is sort of an adaptation of the pre-existing scheme that used to be in operation when we were in the EU. And it's a funding scheme for planned, so you have to have coming up state provided, so it can't be private, healthcare treatment in EU countries or Switzerland, Norway, Iceland, or Liechtenstein. There's a specific power in the NHS Act that facilitates this. There's some quite detailed criteria which are set out in the link on the slide that I've given. But I think perhaps most important to this is that the criteria includes that the NHS must confirm it can't provide the specified treatment in a medically acceptable time frame. So it has to be treatment that the NHS would provide, but just can't. So it's about getting it quicker. It isn't about getting something you wouldn't otherwise be able to get. And it's discretionary. So Martha's rule, I mentioned this at the beginning in relation to urgent situations. We've probably all heard about this in the news. This is the situation. There's no legal right for NHS to fund a secondary opinion from that adopted by the clinical team who are in place providing care. However, following a successful campaign in relation to Martha, who was a girl who died from sepsis after repeated attempts by her parents to get a second opinion as to whether or not she might have sepsis or some other serious illness, her parents launched this campaign, and NHS is now rolling this out to every acute hospital in England. And essentially what it means is that, in essence, if a patient wants a different opinion, then they can ask for it, and the hospital needs to ensure that they have it. It's been very successful since it's been rolled out, and it's saving lives, really. It's quite remarkable. Important to note, it doesn't have any legislative footing. So if this was actually denied to you, then I'm not really sure that there would be any sort of, well, you wouldn't really have time for a public law legal challenge. It might be relevant, however, to any clinical negligence claim. So finally, what's the future for patient choice? Well, the 10-year health plan does actually have quite a lot in it about patient choice. It's going to remain a core part of NHS policy and the political ambition for the NHS. And one of this is a new choice charter, which has got 5 new, what's described as mechanisms, which I've summarized here. Um, and one of the sort of big ideas is that the NHS app is going to be the sort of central point for the NHS, and it's going to include something called My Choices, which is the idea being it's going to be like all other kind of consumer interactions. And I've set out an extract from the report from the plan on the slide there. But given the time, I won't go into any detail on that. And I think it's now over to Leon to talk about some of the common problems that emerge in patient choice.
Thank you very much, Charles. As a quick whip through, but showing us all the main areas where patient choice emerges, and also giving some indication of the hurdles that anyone has to surmount to exercise patient choice. So next, it gives me great pleasure to hand over to Leon Glenister to look at some of the common problems and some of the issues in slightly more detail. Leon is also a barrister at Landmark. He's a specialist in public law. He was the joint editor of NHS Law and Practice, and therefore not only does he have a detailed knowledge of patient choice, but it also sits within a comprehensive knowledge that he has of the wider legal frameworks applying to the NHS, and he's been in numerous leading cases involving the NHS, and is on the Attorney General's A panel of counsel, which is the very highest panel for the Attorney General. Leon.
Thank you very much, David. I am going to talk about 4 issues that have arisen in a combination of my practice, researching the book, and things which I think are ripe for some kind of legal analysis or challenge. The first 2 are in relation to demands for treatment. The first by reference to treatments that are not offered by a clinician at all, and the second by reference to possible treatments or services that are offered nationally but not necessarily locally by a patient's ICB. I'll then look at a surprising lack of clarity on the status of the patient choice provisions, in particular in relation to whether they afford a patient a direct right to challenge that could be enforced by way of judicial review or otherwise before the court. And lastly, as Charles alluded to, I'm going to look at the now common practice of referral hubs, which operate within ICBs, and some of the issues I've seen emerge in relation to those when I've been asked to advise on them. So let's kick off with the demands for treatment. So can and this is perhaps the overarching question in relation to patient choice, can a patient demand that a doctor provides a specific treatment for them? The fairly short answer to that that's been made clear by the court on now a number of occasions is no. The leading case for a long time was Burke, which was a challenge by a patient with a degenerative condition to guidance issued by the GMC in relation to end-of-life decisions, because that would in the future affect them. You may have come across it in judicial review challenges where it said there's a hypothetical claim, because it's also the leading case in that area. But it also dealt with this issue of patient choice, and it said the framework is as follows: a clinician provides treatment options which the clinician considers are clinically advised. The patient decides whether they will accept any of those options, or they may decide to decline them all. The doctor then provides any chosen option, and if the patient refuses all options, the doctor will discuss the treatment and then offer a second opinion. So that's the status. Now, that principle came into sharp focus in JJ and Spectrum, which is a case which David and I were involved in. And it arose from very unusual facts. There was a severely disabled prisoner who was unable to feed himself. He wanted to be fed by medical staff solid foods, which include things like boiled sweets. The medical staff concluded this was unsafe. It could lead to a risk of choking, and that in turn may be something that could be fatal given his condition. Now, the patient says, I don't care. This is what's given me pleasure in my current situation. And I have a right to choose, and I choose to have a solid food diet. And of course, if he wasn't in prison, someone else could help him feed himself. And obviously, if he could feed himself, he could choose the solid diet, a solid food diet. In that context, diet was a form of medical treatment, and it was therefore considered in light of the legislation and case law on healthcare. In short, none of the circumstances which arose made any difference to the core issue in Burke. The clinicians considered a solid food diet to be unsafe, and that was an end to the matter. The patient's right to choose didn't extend to effectively, and maybe this is the logical position, requiring someone else to do something which in turn breaches their autonomy. So in short, a fairly clear answer: patient cannot demand a treatment or service that's not on the table. And the commissioner but the clinician would be under a duty to provide a second opinion if Burke is right. So let's then move from the general to the more specific. So to what extent can an ICB say, these are the services which we are offering, and to what extent do GPs have an obligation or otherwise have to consider the limits of the ICB's policies when determining what secondary care a patient requires? Now, all of this arises from Regulation 39 of the 2012 regulations, which Charles referred to. Now, that regulation states an ICB has a duty to make arrangements to encompass the choices set out in Regulation 39(2), which is then extracted. Now, as of 1st of January 2024, the underlined words were added. So the choices are picking up at 2. The choices specified first of the paragraph, i.e. the arrangements. In respect of a first outpatient appointment with a consultant or a member of a consultant's team, inclusive of any subsequent treatment required as a result of that elective referral of any clinically appropriate health service provider with whom any commissioning body has a qualifying contract. Now, health service provider is broadly defined, and if it is any body or company that is contracted with an NHS provider, such as another ICB. So the outcome of that is there are 3 categories of secondary service. The first is that treatment which is included within the ICB's own policies. No issue there, because the GP and ICB would agree to commission that service. The second is a treatment that's outside the commissioning policy of any ICB. Again, there's no problem, because that wouldn't be inclusive of what's set out in Regulation 39(2)(a)(i). The issue arises in relation to treatment that's offered by one ICB but not another. And what the amendment does is to require an ICB to provide a choice for a patient to elect to see a provider which it doesn't have a contract with, but another ICB does. And that election applies not only, as it did, for a first appointment, but for the entirety of subsequent treatment. So why has that amendment been made? There aren't any explanatory notes to the amendment regulation, but what it appears to do is to try and get round the previous criticism of postcode rationing, so some treatments being provided in some areas and not others. But what it also does is possibly drive coach and horses through ICB commissioning policies on the limits of what they agree to commission and therefore budgets. It means ICBs possibly have to commission services which it's decided not to commission. And a good example, which we raise in the chapter, is IVF treatment. It's very expensive, and ICBs differ dramatically in the extent to which they fund and commission IVF treatments. So if someone attends a GP surgery and the GP considers IVF is clinically appropriate, that patient under Regulation 39 can ask to see a provider even if the ICB to which the GP practice is a member of hasn't got a direct relationship with them. So the ICB may have decided not to commission IVF or limited it to one cycle, but that doesn't prevent the GP from referring that patient to a provider that was prepared to provide treatment in accordance with another contract with another ICB, which was more generous, so more than one cycle, for example. Charles also noted the issue in relation to double payment. So this can also affect ICB budgets, because if an ICB contracts for treatment through a block contract, i.e. one which requires or which specifies delivery of a service over a period of time at a fixed price, it means the ICB has to pay for the block contract, but on top of that, any other services which are the subject of patient choice. So oddly, the more patients use patient choice to engage other providers, the less incentive there is on an ICB to have a block contract to deliver services. So moving on to the next issue of my four, can a patient enforce their right to choose in court? So as I alluded to before when I looked at Regulation 39, the duty on ICBs and commissioners is to make arrangements to enable patient choice, and that's set out in the way I've just explained. The question then is, what does that mean? So, I mean, on its face, the ICB has to have some kind of policy. Now, NHS England doesn't recommend any form of policy. There's no sort of draft policy on their website, but the policy does have to be publicised by the ICB pursuant to Regulation 42. So if there's a failure to have a policy or publicise the policy, then that would be a straightforward breach of the regulations. The question, or the more vexed question, is whether an individual, i.e. a patient who seeks to exercise patient choice, can rely on Regulation 39 to create a directly enforceable right. And the question is whether that's Regulation 39, a duty to make arrangements, is a target duty or an individual duty. And as some of you who have been following this case law, which has there's been a few cases recently, will know a target duty is one, which is a broadly used term, but it's generally where there's a duty to act with a view to achieving an outcome rather than the outcome itself. If the duty is to achieve a specific outcome, that's an individual and absolute duty. And in this NHS sector, the duty arose, or those terms, the duty to make arrangements arose in a case which I'm sure many of you will be familiar with, AA in NHS England, which David was involved in at first instance, where that was a duty in relation to waiting times. So the duty to ensure not less than 92% of a cohort referred for non-acute treatment had a wait time of more than 18 weeks. So that duty was held to be a target duty. The term duty to make arrangements wasn't conclusive, but the context of that duty was, which was that actually many events or circumstances completely outside the control of the commissioner, here it was NHS England, could have led to the breach of the duty. So staff shortages, strikes, an increase in demand, and the balance of wait times was also something that would then have an impact on financial resources, which, as you will be aware, courts are very careful about before they encroach into looking at how public bodies attribute or distribute financial resources. So in all of that context, there wasn't a directly enforceable right in relation to wait times. I'm not sure that applies here. Those wider considerations don't really apply in this context. And actually, the entire premise of Regulation 39 and patient choice is a right of an individual patient to choose. And the substance is lost a bit when the patient can't enforce that right in any specific way. So in my view, a court, I mean, this is the bit that's ripe for challenge, but in my view, a court would actually find the opposite of AA and find Regulation 39 did involve a directly enforceable right. I'll move on to then the last of the legal issues or areas in which there is some kind of legal analysis to be had by a court, and that's in relation to referral hubs. So I'm sure many of you will come across referral hubs, and they're called a variety of things across different ITBs, but broadly, they are a single place where referrals across an ICB for elective services go to be onward referred. So GPs will refer a patient to the referral hub. The hub will then send out an onward referral. The idea behind them is to ensure there's greater consistency across the ICB network in terms of what patients are getting, but also to ensure a closer management of ICB budgets to ensure that there is management of what onward services are being funded. Now, they have been recognised through amendments to the regulations, and I've given you the regulation there, but they are referred to as an interface service, which is one of the many things which it's not immediately obvious what is meant by that, and even the description and definition of that is not entirely clear, but it appears to relate to these referral hubs, and a referral hub can make an elective referral in accordance with the regulation. So there's no, I don't see a legal issue there as to the sort of virus of the regulations. But that doesn't stop a GP making a direct referral. Part of the essential services within the standard GMS contract are the referral of patients to other services within the NHS, other NHS bodies. And that is the basis of why I think is the first of the legal issues of referral hubs. So the GP will have assessed the patient, will generally know their medical history in some detail, particularly if that individual has been with the GP for some time. And that they will have come to a view, the GP will have come to a view on what specific course of treatment that individual requires. Now, previously, it would have referred them directly to a secondary care provider. And they have a duty to act in the best interests of the patient. Is it really in the best interests of the patient to refer them to a referral hub to individuals who are looking at their case on paper, having never met the patient, over just referring them directly to what provider that the GP thinks is necessary and appropriate? Question. I mean, it's a question of duties of doctors, but it does create an interesting issue as to what the doctor should be doing as a matter of duty. The second issue that comes up with referral hub is, and this is probably the more crucial one, is how they implement patient choice. The whole premise of the referral hub is to, well, one of the main premises is to manage cost and implement commissioning policies by the ICB. I have already just gone through how those aren't, under patient choice regulations, the end of what a patient can ask for. So how do patient choice arrangements, which are very complex and actually give possibly quite wide-ranging rights. How are those patient choice arrangements implemented within these referral hubs? And the answer, in my experience, is not very well, because there's just a direct conflict between what the referral hub is there to do and patient choice. So it is important if you're advising, ICBs on this, to ensure that the regulations in relation to patient choice are implemented through the hubs. But also, if you're advising patients, referral hubs can have their legal issues as and when they conflict with the regulations we've been discussing today. That, I think, takes me to the Q&A, and I'll hand back to David to see if he's got anything to ask.
Well, thank you very much. If there are any questions from everybody who's on the webinar, now's your time to put them. But meanwhile, I've got a question for our two panelists. A woman goes to the GP and says, I want NHS funded IVF. The GP says, I'm afraid our ICB doesn't commission that here. The woman says, I've heard a report of patient choice rights, and I'm told you can refer me to a hospital in Bolton, which does provide IVF, and what's more, because other ICBs commissioned it up to 3 cycles in accordance with the NICE guidelines, I'm entitled to that. Would you please make the referral? And the GP says, I have enormous amounts of sympathy for you, but I don't think I'm allowed to make the referral when the ICB policy is not to fund IVF. Now, Leon, I think you're right that in those circumstances, the GP is in the wrong. But the question is whether it's a private law cause of action that the woman has, or a public law cause of action. How does she effectively challenge the GP who sticks with the local policy, or is the GP entitled to stick with the local policy? Now, who wishes to offer views on that? I don't think there is a straightforward answer.
I don't think it is straightforward. I think it's, I mean, maybe this with my public law hat on, I think there is a viable judicial review for the reasons said under issue 3. So that person who goes in has every right under the patient, at least the sub-regulation 2, to ask for that provider involvement and ask for 3 cycles. The only limitation on a doctor when the patient goes in is whether it's clinically appropriate. I can't see how a lawful decision could be made on clinical appropriateness by reference to effectively a funding limitation on the ICB, and I don't see ICB policies feeding in at all to regulation 39. So what you would be doing is challenging probably the GP for taking into account an immaterial consideration under the application of the decision, or possibly challenging the ICB policy as being inconsistent with patient choice. The question then is whether that's a directly enforceable right, which I think the answer is yes. I mean, the only other private law claim would be against the doctor for not acting in. There might be a best interest negligence type tort claim, I think. But I think, maybe this is my public law hat, the easier claim would be a judicial review.
Charles, anything to add?
I think I agree with Leon, but just sort of playing sort of devil's advocate. I think one objection that the practice might take in that situation is that there's an alternative remedy available to you. You could pursue regulatory complaint routes, or alternatively, you could, as Leon said, try to obtain a perhaps a best interest declaration in Part 8 proceedings might be a way of going there. I mean, I would imagine in reality, if you actually get to the stage of sort of formally issuing proceedings, that this would get resolved before it ever ends up in court, and one would hope that would happen. What's interesting, and I was just going back to have a reflection on this, is that as far as I've been able to see, the Department of Health and Social Care's NHS Choice Framework is silent on this issue and on a number of these issues, but quite detailed on some of the other ones. And I think that is interesting, and I think something we haven't had time to explore today, but is something worth reflecting on, is the extent to which these NHS England and DHSC guidance documents are accurately stating the legal position when that legal position is so uncertain. And those are in reality going to be the first port of call for any patients who are looking to kind of exercise these patient choice rights. What you also do see, though, is certainly in the DHSC NHS Choice Framework are some examples of choosing sort of specific scenarios that are set out. So, Richard, who's suffering from pain when he moves his knee, etc., etc. And what would be an interesting question to see in practice is the extent to which you could rely on what the guidance says, even if that goes over and above what the law says, to enforce a right against GP practice or ICB or NHS England. I don't think that would assist on this particular occasion, but it might in other scenarios. But that's something to just have at the back of your mind that we didn't really have time to explore today.
Can I offer some further and alternative thoughts? Because I agree with Leon and I agree with Charles, it's not entirely straightforward. First of all, I don't think that the existence of the choice policy makes an NHS ICB commissioning policy unlawful. It seems to me ICBs have to have commissioning policies. They're required to do so under the 2012 regulations, and they're required to have them and publish them. And as they have an element of discretion, I've been involved in a number of IVF cases, given that it's non-binding nice guidance, as long as they've had a regard to it, it seems to me that would be a lawful policy, even though you have a route of avoiding it through the choice framework. I mean, I think the practical answer to the patient may well be a negligence claim, because the doctor is required to understand their legal duties and the legal framework within which the patient operates. And if the patient says, I have this right, please go away and seek some advice to check I've got the right, I'm coming back next week and I want the referral, and the GP either doesn't check or checks and gets the wrong advice, and therefore doesn't exercise a clinical discretion in circumstances where it's clinically appropriate to refer somebody for IVF, I think there's a plain breach of duty. But the JR, it seems to me, would be against the GP, because it's the GP that's the decision maker, not the ICB. And it's the GP who's refusing to make the referral, which, as Charles explained, is the gateway to opening up patient choice rights under Regulation 39. As Leon rightly said, I think if you threaten the GP with a JR, GP's likely to get some legal advice and you'll get the referral. So you can probably take those routes in practice. And if the GP digs in, of course, the alternative is simply to go and incur if the woman has the financial resources, incur the costs and then sue for the costs in negligence, because those are costs which you ought to avoided, you ought to have avoided, because it ought to have been available to you as NHS funded treatment. It's a really difficult area. We've had a question on someone's asked what was the name of the conference that I referred to initially. Landmark Chambers is joining with the Legal Action Group, who are the publishers of NHS Law and Practice, to put on an all-day conference on updating NHS law, which is taking place in central London on November the 5th. And there'll be a range of speakers. So and you will be all emailed a link to the conference once the webinar is finished. But the idea is to provide practitioners who are in the field with you across a whole range of issues affecting those who practice in NHS law. So that's happening on the 5th of November, and it's jointly all being organised by Landmark Chambers and LAG, who are, of course, one of the leading bodies for doing public legal education. Leon and Charles, is there anything, we haven't got any more questions, which perhaps reflects the complexities of the issues here, although we have everyone is staying for the attendance. Is there anything else that you want to, any questions you want to raise, or any other issues you want to discuss?
Just one further thought that came to me as you were talking about whether you would JR the GP practice or the ICB or whatever. I think it would be worthwhile just reflecting on the general obligation on NHS England and ICB's, the target duty, as it were, to, in the exercise of their functions, act with a view to enabling patients to make choices with respect to aspects of health services provided to them. And so there is a possible question whether ICBs should be making sure that their policies in respect of commissioning don't purport to advise GPs to be impermissibly restricting the referrals that they can make when they consider it's clinically appropriate to do so. Whether that would be within the scope of that duty, I don't know. I mean, that would be something to litigate, but it's certainly not totally out of the question that it might be.
I think that's a very interesting point, because in one sense, the combination of the regulations puts and the duty puts ICBs in a very difficult position, which is, on the one hand, they have to promote their own commissioning policies, and on the other hand, they have to promote the right of patients to bypass them by exercising patient choice rules. And that appears to me to be an inconsistent, asking them to take almost inconsistent positions, and flies in the face, as you both said, of the issue about budgetary control. Namely, how on earth are they supposed to keep control over their budgets if at the same time patients have the right to exercise choice and therefore force them to incur unplanned expenditure entirely outside commissioning policies? And I don't think either or any of us have a real answer to that contradiction. Do we, Leon? Charles?
Not from me.
Well, it's 5 minutes to 4. We've agreed we'll finish. So can I say a huge thank you to Leon and Charles. A lot of people have stayed on right to the end. Preparing these talks takes a huge amount of work and thinking. The slides will be available after the talk. The webinar is available. If you have more questions, then please contact us. Leon and Charles are available for instructions in this area in the normal way. Thank you very much, and good afternoon.